Morning, everybody. It is 8 a.m., and we are going to talk about forms of tenancy and property ownership this morning. Welcome to my webinar. Um, this is probably one of the most asked questions that I get in a closing by buyers. How should I take title to my property? And I just felt it was important for you as the realtor to know what the options were. So if the buyer asks you for your opinion, you can have some thoughts about what the types of tenancy are. So again, I am an attorney, Sam Saad, and I am going to start off with a disclaimer that I'm giving you advice. It's not legal advice. And if you have specific questions, we need to establish attorney-client relationship. So I've been practicing for over 20 years and I focus on real estate and business law. My firm handles litigation, probate, estate planning. We have offices throughout Southwest Florida. I am the scribe of the Legal Resources Committee at NABOR and on the Joint FAR Bar Drafting Committee for the Florida Bar and Florida Realtors. So if you have any contract questions, we can address those as well. Let me just say a little bit about our title company, Paradise Coast Title and Escrow, which we are now very excited to, we close in Spanish, hablamos español. We are always up to date on the latest information in the closing process. And if you have specific questions about that, you can call me anytime on my cell phone. Today, we're going to be talking about tenancies and how to hold title to real property in Florida. So we're going to talk about holding as a single person, a married person, husband and wife, joint tenants, tenants in common, and then if you take title as a trustee of a trust or in a limited liability company. Before I dive right into the tenancies, does anybody have any questions about about the title process? The title is stated on the deed from the seller to the buyer. However, the title is listed on the deed from the seller to the buyer is how the buyer takes title. So you'll hear in title, we talk about the take title. What is the take title? That's the names and the tenancy status on the deed from the seller to the buyer. So just right off the bat, what is a single person? It's just the individual. Barbara Buyer takes as a single person. It's in your individual name. If you were to pass away before you sold the property would go into your estate. If you had a will that talked about the disposition of the property would be disposed of according to your will. If you did not have a will, then the intestacy laws would tell the court how to give your property to your heirs. It's a very simple form of tenancy, and it's simply your name. Nothing. It doesn't even need to say a single person on the deed, although that's helpful for later when you go to sell the property to avoid signing a marital status affidavit. Very simple. The next form of tenancy is a little bit more complicated. If you are a married person, but you want to take title to the property individually as sole and separate property, then again, you would take title as, Barbara Buyer, a married person this time. Again, your interest would be probated. Barbara's interest would be probated upon her death. It would either go under her will, or if she did not have a will, it would go under the intestacy laws. Although now, if she's married and it's homestead property, unless the language on your screen is in the deed or somehow been recorded for the spouse to waive their homestead rights, then homestead laws would apply under the Florida Constitution. So when you take as a sole and separate property, you need to have a statement in the deed, and this is copied right out of the statute. By executing or joining this deed, I intend to waive homestead rights that would otherwise prevent my spouse from devising the homestead property described in this deed to someone other than me. So Barbara would have that in her deed, and her husband would need to sign the deed. So make sure you hear that. The husband would need to sign a deed waiving his homestead rights. Otherwise, when Barbara passes, then her husband would get the property. So up next is a more complicated form of tenancy for married persons, tenancy by the Entireties. And this creates an estate by the Entireties where the property automatically goes to the surviving spouse at death. And all you really need to do to record the change in title is for the surviving spouse to record the death certificate of their deceased spouse in the official records of the county, and voila, the tenancy is transferred to the surviving spouse in their own name. This is really considered the highest form of tenancy among people. And the husband and wife, it creates kind of a legal fiction in that the husband and wife own the whole thing. So each of you owns 100% of the property, which is kind of odd since normally two people couldn't own 100% of the same thing. But in this case, it creates a legal fiction that occurs. How do you do that? You have to have the 6 unities of title. This is not super important for you to know as a realtor, but as a matter of intellectual curiosity, you need to have the unity of possession, interest, title, time, marriage, and the right of survivorship. And it is very important on this deed to a husband and wife that it say a married couple or husband and wife or tenancy by the Entireties after the name. So you can see here in the example, my wife and I hold our property, Sam J. Saad III and Amy Saad, husband and wife. So the court knows, all comers know that this property is tenancy by the Entireties of Amy and I. It's a little different than our next tenancy, which is joint tenants with rights of survivorship. This creates very similar rights amongst the parties, the owners, except they're not married. And it allows two individuals to own property where the property automatically transfers to the survivor upon the death of the other. So just so you understand, when two people or more are on title and one of them dies, then the properties goes to the remainder people on title automatically by filing the death certificate of the deceased person in the county where the property is located. You don't need a probate, just like tenancy by the Entireties. And everybody is equal owners. They all own the same thing. Again, it's kind of a legal fiction, and there's no probate. And unlike tenancy by the Entireties, which creates other rights, joint tenants with rights of survivorship is not limited to married couples. I kind of made an economics joke here in my slide. If you can see, I've got John Smith and Karl Marx as joint tenants with rights of survivorship in the example. For those of you that know who those two people are, it would be very odd for the most prolific property rights guy and the least prolific property rights guy in history to have a property together. I just thought that was funny.
It was.
So the next form of tenancy is the tenants in common slot tenancy. And this is a very flexible way of holding property. You simply own your interest in the property. If there are two people on the property, you each own half. If you have the default is for each property owner to own their proportionate interest. So if you've got two people on title, you each own half. If you have three people on title, you each own a third. There are no survivorship rights in a tenants in common property. The tenants in common each own their individual interest. And when that person passes, their will or their estate plan, if there is no will, the intestacy laws control, and the other remaining co-tenants would then own the property with whoever you leave your interest to. So just to say that another way, John Smith and Karl Marx are on title. Karl Marx dies, and now John Smith owns the property with the heirs of Karl. So Karl's heirs are now in title after they go through probate. You have to go through a probate to do this because you don't have it designated in the deed. And then all of those people would own together. And if they wanted to sell, if John wanted to sell his interest, he would have to deal with Karl's heirs, and the heirs would have to sign a deed as well, or John would have to sue them in what's called a partition lawsuit and break up the title, which is very expensive and not very much fun for any of the parties. So those are the basic tenancies. The other way, two ways that I want to talk about that you can hold title are tenancies. But if you take title in trust, then you got to remember a few additional things. You hold the tenancy is by the trustee, and you could have one trustee as a single tenant, or you could have multiple trustees as co-tenants, but not as tenancy by the entireties and not as tenants with rights of survivorship. So they would be tenants in common. And I've got a few examples on the next slide. But just wanted to make sure you remember that trusts do not hold title to real property in Florida. Trustees hold title to property in Florida for the benefit of the beneficiaries. But you're always looking for who has the power to sign for the trust. So you may need to find a successor trustee. If there are multiple trustees, you will have co-trustees that probably need to sign. The other thing I'll mention about owning property in a trust in Florida is that the power and authority to protect, to conserve, to sell, to lease, to encumber, or otherwise manage and dispose of the property listed in the deed, if you put these magic words that are on your screen, if you put these in your, these I'm highlighting in yellow, in your deed, then you do not need to review the trust agreement when the trust goes to sell the property if the people listed as trustees are still selling the property. Saves a lot of time and money for the lawyers doing the closing because they don't have to examine the trust instrument, the trust agreement. So again, title is taken by the trustee in trust for the beneficiaries under the trust agreement. So I put a few examples on your screen here of how you can take
Sam, we're
title.
getting an echo.
Oh, Bev, let me mute you. So you can take title in trust as Sam J. Saad III, trustee of the Sam J. Saad III Revocable Trust with the date of the trust. If you've got co-trustees, you could have Sam J. Saad III and Amy Saad, co-trustees of the Saad Family Trust with the date. Or you could have a corporate trustee, such as my corporate trustee, Florida Trust Holdings LLC, trustee of the land trust. You typically would use one of these trust companies for land trusts, not for revocable inter vivos trusts. Any questions on trusts before I switch over to LLCs?
I have a question.
Sure, Batya.
I'm not sure if this is correct, but I've heard different things on this. Can you still have homestead on the property if it's in a trust?
Excellent question. Yes, if the property is held by the trust for the beneficiaries and the beneficiaries have the words in the trust that says they are in control of the property and can own the property, own the beneficial interest for their lives, then you can get homestead on the property even if it's held in trust, even if it has a corporate trustee. Other questions about trusts? Okay, let's talk about LLCs and then we'll take general questions. So LLCs are great form entities for owning property in Florida. There are two documents that control LLC operations. There's the Articles of Organization and the Operating Agreement. The Articles of Organization is kind of like the Declaration of Independence. It declares that the LLC exists. It's filed with the state, the Secretary of State, and voila, you have an LLC. It can do whatever the law says it can do, which is anything that's lawful, like a person, or you can limit it to real property holding or other activities in the Articles of Organization. The next is the constitution of the LLC. That's the operating agreement. That's the manual that tells you who does what for the LLC. If it's not clear in the Articles of Organization, this is normally a multi-page document drafted by an attorney. And it'll say who the managers are. It'll say who gets what money when, things like that. So when you're doing a deed into an LLC, you're looking for who has the power to bind the LLC. And LLCs are either manager managed or member managed. So in a manager managed LLC, the manager signs for the company. In a member managed LLC, the members sign for the company. And this is a big difference because you may have a manager who is not a member. So in a big LLC that's a corporation, big corporate LLC with a lot of operations, you may have layers of management with authority to sign for the company, and they may not be the owners of the company. Very important to know who has the power to sign, and that is in the operating agreement. If it's not in the operating agreement, we look to the articles. If it's unclear in the articles, then we say that everybody involved in the LLC has to sign off on it, all the members. And there's no such thing, by the way, as a managing member in an LLC anymore. That's an old concept that Florida got rid of in 2014 time frame, around there. So if you see managing member, that's an old term, and those people are just members, and all the members would have to sign off on the LLC. So you take title, I should have put an example, but you take title in an LLC, just name of the LLC, as a limited liability company licensed to do business in whatever state it's registered in. And you do not have to register your LLC in Florida to buy property in Florida. If you're going to collect sales tax or you're going to sue somebody for back rent, then you would need to register in Florida. But just to own the property, you do not need to have the LLC registered in Florida. And with that, does anybody have any questions on LLCs? How to take title in an LLC? Does anybody have any other questions on the stuff I've covered today? Tenancies, tenants in common, tenancy by the entireties. Mostly this stuff is things that I have to worry about on the title side, but if you've got a question or you have a client that's asked you questions about it, go ahead and shout them out.
Yeah, Sam, this is Randall. I'm
Randall.
not sure if you cover this or would cover this, but I've heard in Florida, if you have just a single owner LLC, let's say you're holding real estate in that single owner LLC, that you're not really protected from any kind of litigation or liability, that you need a two owner LLC. Do you know if that's true? I've just heard
That is partially correct. Yes. So that's a great question, Randall. So there's the Olmstead case in Florida from several years ago that changed the law, and then the legislature reversed the Olmstead case. And what it says is, if you have a multi-member, two or more members in an LLC, then the only thing a judgment creditor can do if they get a judgment against the LLC, say there was a slip and fall in a rental property and the property is owned by an LLC and the LLC is owned by two guys, they cannot come after the two guys. They can only come after the interest inside the LLC. Now, there's another liability out there called outside liability. Say you got two guys and they own an LLC that owns a piece of property, and one of the guys gets in a car accident and he kills somebody. It's a really bad accident. And he gets sued. They cannot take this guy's LLC interest from him, and they cannot take money like the rental income out of the LLC. all they can do is get a charging order against the guy that was in the car accident. And that owner, if he ever gets any money out of the LLC, then they can take the money. So what you simply would do is not give him money out of the LLC. You give it to him a different way, and then voila, he's judgment proof as regards to the LLC for multi-member LLCs. Now, if you have a single member LLC and there's no other way for the judgment creditor to get paid, and they can prove that it would be very hard or a long time or a difficult process for them to get paid, then they can go after the LLC interest of a single member LLC. So you are partially correct, Randall, that you get some protections for a single member LLC from inside creditors, but outside creditors, if there's no other way, then they could take that LLC interest from the judgment debtor.
Okay. All right. Thank you.
Yep. Tanya is asking, can title be held by husband and wife be transferred to tenants by the entirety? So Tanya, or Tanny, I mean, if you hold title as husband and wife, that is tenants by the entirety. So you wouldn't have to make a change.
Okay.
And then Anna, you were asking if they're husband and wife. Go ahead if you want to unmute yourself and explain that question. Anna, I don't see you. Okay, Anna, if you want to unmute yourself, come back. Oh,
Okay, my question is that if the LLC, the owners of the members of the LLC are husband and wife, are they protected?
yes. So there is an open question on this case has been asked many times. I've not seen a court case. If husband and wife who are they're a married couple, they're considered one legal entity by the law. If they own an LLC and the LLC owns a piece of property and there's a problem, can they go after the husband and wife? The answer is they may be able to if there's a problem inside the LLC, but they would not be able to if there was a problem outside the LLC. So in my example, if the husband got in a car accident and killed somebody, they couldn't take the property or damage the title to the property held by husband and wife, even if it's an LLC.
Okay, thank you.
Patricia, you asked how is a trust handled in a will? Patricia, wills can create trusts for like minor children. So like that's what I do in my will. I create a trust because my kids are under 18. So you can create a trust in a will, but if you have a trust and the property is held by a trust, then the will would not control the disposition of the property. The trust agreement would control the disposition. Yes, Bev, I'll share my slides. Other questions you guys have about this? Anita, you were saying a tenancy by the entirety does not require a probate. That's correct. When one of the spouses passes, the next spouse gets the property automatically by filing the death certificate in the county.
Sam, just a quick follow-up just on
Sure.
so let's say I have a trust and the trust owns multiple LLCs that own real estate.
Yep.
Does that change anything? Like, for example, you still have to have each LLC would be owned by the trust and you'd have to have a second entity owning it then with that?
Well, no, that's if you, so Randall, if you've got a property that's owned in an LLC and that LLC is held by a trust, you're good. Because
So
if there's a slip and fall on the property and they sue the LLC, then they could only get what's in the LLC. If there's a slip and fall by somebody, or if there's a problem with the trust, you wouldn't really, it would be very tough to sue a trust in some type of accident or liability event. You would sue the beneficiary, you might sue the trustee, but it'd be very difficult, I think, to go after a trust and
so
take
you
the
could the
LLC
trust
interest in
the
that way,
beneficiary
unless, of course, the trust had other issues.
But they could sue the trustee and the personal, go after the
Well, if
personal
the
assets.
trustee, for example, got in a car accident, then they wouldn't be acting in their capacity and the trust would be safe.
Okay, but if there was a slip and fall on a property owned by an LLC owned by that trust, you're saying they could only go after what's in the LLC, or they could
Right.
go after the trustee
No,
that
they
control.
can only go after what's in the LLC. They can't pierce the corporate veil.
And so there's no need in that case to have a second partner or a multi-owner LLC if it's owned by a
No,
trust.
no,
Okay.
that's inside liability. You don't need a trust for that. You don't need multiple
Oh,
people for that.
okay. All right. Thank you.
Yep. And Randall, if you've got a specific situation, reach out to me afterwards.
Yep.
I do a lot of asset protection for people. I can sit down with you. There's a lot of permutations. Just as a quick aside, the whole thing about asset protection is layering. You want to
Right.
put up insurance, you want to put entities in place, and you want to protect yourself in layering. So we'll talk about that separately. That's a good
Okay.
presentation of all of itself.
Great. All right. Thank you.
So Arisima, you were asking how to change title from a single person to tenancy by the entireties. You would simply need a deed. The single person that owns the property, you would deed it to the joint tenants as husband and wife, and voila, they are husband and wife owners of the property. Bev, you had a question about life estates. So life estates, Bev, when you want to create a life estate, you simply add the remainder person to the title. So like if I wanted my kids to have a life estate, my title would say Sam and Amy, Sam J. Saad III and Amy Saad, husband and wife, comma, for life, the remainder interest to my children. And you put your children's names. So you create the life estate in the deed. You can create an enhanced life estate if you put the magic words in the deed. So it could be Sam J. Saad III and Amy Saad for husband and wife for life. Remainder interest to Sam and Lola Saad with the right to, and then I put the magic words from the statute, and then I can control the property all through my life, and I don't need my children to sign off on it. I'll do a separate video on life estates. There's a lot on that.
Thank you.
Of course. So, Via, you're asking, does the tenancy by the entireties hold for non-married? No, tenancy by the entireties, Via, is only for married people. If you're not married, then you would use a joint tenants with rights of survivorship tenancy. Joint tenants with rights of survivorship, and you put that right in the deed. Let's see here. Other questions? Yeah, I'll share the slides. I think I said that. Okay. Other questions? You can unmute yourself or put them in the chat.
Sam,
Batia?
what about quitclaim deeds? Do you have any comment on like the validity of that? Can they be
A
contested?
quitclaim deed is fine. It's not really an insurable deed. Quitclaim deeds basically mean I'm quitting the claim on this property. Whatever I own, whatever it is, if it's a life estate or a tenancy by the entireties, whatever I own, I'm giving it to you for some amount of money or for nothing, and I'm walking away. That's what a quitclaim deed does. It's not really a good deed. A warranty deed is better, and a quitclaim deed is not insurable. So for titling purposes, in my world, we don't use them unless we absolutely have to. They're very good, like when a husband wants to add his wife to title, that's a good use of a quitclaim deed. But generally, we avoid quitclaim deeds if we can for transfers between people. Other questions? All righty. Oh, one more. If you file a quitclaim deed, can the lender call the note since there's a change? Yes, Janet, that's a great question. If you quitclaim property that has a mortgage on it, you will cause the due on sale clause in the mortgage to come due, and you will owe the full amount of the loan. Kelly, you're asking if you're a single person and own a property and then later get married and then die, does the home go to probate? If it's homestead property, Kelly, then it would not go to probate because the surviving spouse, if they live in the property, if it's their homestead, they have special rights under the Constitution of Florida. And a homestead is its whole other presentation. All right. Thank you, everybody. It's great to see you all this fine morning. I'll be back soon with more. If you have any questions, shoot me an email or a text. Talk to you all soon.
Thank you, Sam.
Thanks.